Hello. Many civil cases, or rather conflicts that lead to civil cases, start with mistrust between the parties. Basically, each party, or at least one of them, thinks that the other party is acting in a dishonest, uh, excessive, unreasonable manner, or so-called in bad faith. And based on that belief and thinking that it's evident to anyone that a reasonable person would not do this, or a reasonable person or honest person would not do this, uh, some people are like being offended and outraged, are ready to go to court. But when it comes to good faith, there is one legislative decision which was made quite some time ago. And in a way, it was an idea to inject some sort of presumption of innocence in the civil litigation process. That legislative decision was codified in the Civil Code of Quebec this way. Like, good faith is presumed. What does it mean? It means that unless you prove, not only just insist, not only present it otherwise, but prove, the other party is presumed to have acted and to continue to act in good faith. What does it mean? By more or less established approach, good faith means that the party is presumed to have acted in good, honest intent and conducting themselves in a reasonable manner, as like reasonable people would do, as opposed to bad faith, which is the opposite. Like, it was dishonest, it was unreasonable, there were excessive demands, for example, in the context of negotiations or like contractual relationship. And good faith is usually required, particularly, for example, when it comes to contractual relationship. And there are other like that. This is from the Civil Code of Quebec. But again, do remember that required is one thing, but it's also presumed. So yes, the counterparty, contractual counterparty in negotiations or just in civil responsibility situation, they're required to act in good faith, but they're also presumed to have acted in good faith. So hence the sort of presumption of innocence. So it's on you to show that the person was acting with a dishonest intent. Sometimes it's possible to show, particularly if so the person left some documents to that effect. Sometimes significantly harder. And in case of a doubt, because again, who would assess the dishonesty, the bad faith, unreasonableness, excessiveness? That will be the judge, the court, the judge. And the judge is a human, so there might be some impressions, but in case of a doubt, and remember that in civil litigation, in a civil conflict, the burden of proof is on the one who is attacking, who is complaining, and the standard of proof is balance of probabilities, meaning that in the eyes of the judge, it should be that rather than that, not 100% one or another. And if for a judge, it's not clear if somebody was in good faith or not, then good faith is presumed. So accusing, complaining, asking who would do that, or don't you think is suspicious, it's not enough. If you want to plead in court like bad faith of the other party, dishonest intent, unreasonableness, excessive demands, be prepared to bring up your evidence. Otherwise, however, it is clear for you that the other party was bad person, let's put it this way. Remember in the movie, the producers, it was something like, let's assume for a moment that you are a dishonest man, like assume away. So how much you are ready to assume that the other party is a dishonest man or woman? The burden of proof is on you. And the judge is not, or at least should not be prepared to just remove this presumption of trust in good faith of the other party without significant evidence on your part. Thank you and have a nice day.